Hello everyone. Good evening. Can we all hear me? Good evening. Can we all hear me?
Yes, we can. Good evening, sir.
All right. Thank you.
Salvation.
Okay, sorry. Sorry, my speaker was muted. So first mentor we'll be expecting into this session is Mr. Sand Mbakalu. I'm not sure if he'll be present today, because he is currently he had some issues where he lost a family member and he's currently bereaved. So I'm not sure if he'll be able to join us today. But irrespective, we still look forward to having him if he does join in for today's session. But the first mentor that we are supposed to have today is Mr. Sand Mbakalu. Our second mentor for today, we are expecting in the session later on is Mr. Polarinwa Aluko. We already have profiles here in the last class. The third mentor we're expecting in today's session is Miss Regina Obiechim. All right, Miss Regina is the Obiecheni, sorry. She's the third mentor we're expecting in today's class. Our last but not least of the mentors we're expecting in today's class is Mr. Emmanuel Agher Agerao Yo. Sorry, sir, if I did not pronounce your name very well. I have quite a little difficulty pronouncing local names. So Mr. Emmanuel is a highly skilled and experienced lawyer at Police Aba, Abakoba Legal, a leading law firm in Nigeria. Is a key member of the firm Sports, Entertainment, and Technology Sets Practice Group and Dispute Resolution Team. He served as the IP team lead. He served as the IP team lead. As the IP team lead, Emmanuel is responsible for providing strategic advice and representation to clients on a wide range of intellectual property matters, including trademark registration, enforcement litigation, advising clients on trademark clearance, filing strategies, representing them in opposition, cancellation and infringement processes, copyright protection and enforcement, providing guidance on copyright ownership, registration and licensing, as well as enforcing copyrights against infringements through litigation and other means, patent prosecution and enforcement, assisting clients with patent drafting, filings, and prosecution and representing them in patent infringement disputes, trade secrets protection, developing and implementing strategies to protect trade secrets and represent clients in trade secrets misappropriation cases, IP licensing and commercialization, negotiating and drafting IP license agreements, franchise agreements, and other commercial agreements involving intellectual property rights. Then data privacy data protection and privacy. Emmanuel also supports clients with compliance issues arising under the Nigerian Data Protection Act. Emmanuel expertise also extends to dispute resolution. He has a vast experience representing clients in commercial litigation, arbitration, and other forms of alternative dispute resolution, with a particular focus on IP-related disputes. He is adept in handling complex legal issues and developing innovative solutions to meet his clients' needs. He is a passionate advocate for the protection of intellectual property rights and is committed to helping his clients achieve this business objective. Mr. Emmanuel holds a master's degree from the University of Ibadan and is a member of the Nigerian Bar Association, Intellectual Property Hub, Business Recovery and Insolvency Practitioners of Nigeria, Africa IP Center, that is the NICAB, sorry, etc. He has several publications and has received awards recognition with respect to his work. Thank you once again, Mr. Emmanuel, for joining us. I can see Ms. Regina has also joined in on the call. Thank you so much, Ma, for joining. We hope to have both our mentors that are present now help us do due justice to today's subject matter. So not to further waste any time and for us to get quickly into what we'll be doing today. Like we did last week, we'll be taking mentors presentation. They're about 20, 30 minutes for each mentor. Then we take mentees presentations for 10 minutes each. We would have feedback from mentors, and then we'll take questions and call it a day, right? So that's the progression that we'll be following. Okay, so 20 to 30 minutes each for each mentor, mentees presentation, feedback from mentors, and then questions and answers. So please, the presenters for both groups should also get ready while the mentors are making their presentation. So we'll start off firstly with Mr. Emmanuel. Mr. Emmanuel, you're welcome to today's session. We are happy to have you in class with us. Please, in the next 20 minutes, 20 to 30 minutes thereabouts, we'd like to hear from you, share your thoughts on today's topic, IP for creativity. You're welcome, sir.
Hello, good evening, everyone. I don't know if you can all hear me. Can you all hear me?
We can hear you, sir.
Okay, so good evening, everyone. It's a pleasure having to be here today to talk to each and every one of us with respect to the topic IP for creative and innovators. I'll just quickly share my slides, so just talk to the slide to make it a bit fast. I don't know if I have permission to share my slide, so I can share the slide.
Yes, sir, you can do that, sir.
Okay, thank you. Can you see my slide? Sorry, I'm having to use my phone because it seems my system network is a bit bad, so I'm trying to use my phone to make it very fast. Can you see my slide?
Yes, sir, we can.
Okay.
Yes, sir.
So I'll just as I've been introduced, I'm Emmanuel by name. So I want to ask a very simple question. I equally want to get feedback from the mentees. And that question is very simple and straightforward. And it says, if someone copied your best idea tomorrow, your song, design, or invention, what's the first thing you will do? I want to get feedback from the house as to one of the first things you will do if someone copy your best idea tomorrow, your song, design, or your invention. What first thing would you do? Please, it's an open question to the ask, and I equally want the mentees to tell me one of the first steps and things that they will do if someone copy their best idea tomorrow. It could be their song, it could be your design, it could be your invention. What first step or action will you take with respect to that idea that has been copied? that you've noticed is being used with respect to that design or invention that you've created, that you discovered is currently being used by someone in the market. You can drop your comment on the comment on the chat box, or you can raise your hand and I'll just give you some few minutes to talk. Hello, can the mentees hear me? I just equally want to stay our mind and see how best we understand the topic that we're talking on.
All right, so we have some responses on the chat box. Lauren, if I'm not mistaken, is saying
Please
I
read
will
that. Okay, what did you say?
Lauren is saying I will feel very bad, but I would get a very good specialized lawyer in IP, then I would sue them, right? Azimat is saying I would reach out to them to discuss it and see their reaction or reason, and then know if it will be resolved with ADR or not. Benga is saying bring it to the attention of a lawyer. Others are saying reach out and discuss it privately. Sedo is saying I would meet them and tell them to take it down. So we have quite a lot of comments that are coming in.
So I would thank you very much for having commented with respect to the question that I just asked. I truly appreciate. And that just to tell us possible things and possibility with respect to infringement as it relates to intellectual property rights for creative and inventors. And so I want to say for most of us, we got the idea as to one of the things that we want to do. But the first thing you equally want to know as a lawyer is for you to gather evidence. And so the first thing that you want to equally show is for you to save, screenshot, and gather those evidence. Then the next step after you've gathered the evidence, it might not be for you to send a seed and disease letter with respect to this particular work. Because if you don't have evidence, one of the first things you realize in IP prosecution or in IP practice or in this field as a creative is you usually need evidence to prove that someone has indeed infringed your work. So if you say someone has copied your work, you must be able to show me that that particular person has copied or I have copied your work. And we are equally aware that once you just say, you copied my work, I can easily pull it down. And it ends there, so you might not be able to now trace that particular work. But if you have evidence to show that indeed certain time there's a timestamp as to when that particular work was posted, and you have it already screenshotted and screen grabbed, you have an evidence to show that indeed some certain point in time I copied your work. So the infringement does not only lie in the fact that I took that particular work, for the period that I infringed on your work, hello, can you hear me?
Yes, but your voice is not very
well, sir.
So can you hear me very well now? Am I
still not very clear.
Am I better now?
Yes,
Yes,
sir.
sir.
Okay. So with respect to that particular work, I was talking about you having to gather evidence, which is one. I'm talking with respect to the period for which that infringement was done, you lost economic gain. And as such, you might equally be asking for compensation for the period that that work was in use. And even if the person is taking down a particular work, the person equally needs compensation for that period that the person used the work. And if the person wants to now license that particular work, you can equally go for that and say, oh, if you equally want to use this particular work, I cannot grant you license transfer to this particular work for this amount of fee. So it does not just end because the person that work that you send out and sees that it's later. But equally for the period that infringement was done, there's something that is known as economic gain and benefit and goodwill that ordinarily should have accrued to you that have been lost. That's just to give us a background with respect to IP generally and as a specifically with respect to that particular vision. In my next slide, I talked about what is intellectual property. That is just my own introduction. And I said that intellectual property is a legal framework that protects human creativity and innovations. Hope you're following. I said intellectual property is a legal framework that protects human creativity.
So Mr. Emmanuel's having a little bit of challenge with his audio. I'm sure he'll be joining us very soon. So please, we'll just give him maybe a minute or two to do that. And maybe if after a while he's not on board, we'll go over back to our other mentors that are in class today. All right, so please let us just give Mr. Emmanuel a minute or two.
Hello, can you hear me? I think I lost
Yes,
the connection initially.
we can hear you now, sir.
Okay, network is bad. Okay, can you see my screen now?
Yes, we can, sir.
Okay, so I was talking about the definition with respect to intellectual property, and I said intellectual property is a legal framework that protects human creativity and innovation. Now, for Nigerian creatives, you're talking about musicians, filmmakers, designers, inventors. Now, when you talk about inventors, you're talking about engineers, scientists, tech founders. Now, IP is the currency of value. It turns idea into commercial assets. That's what IP, and it's very important that we know that indeed it is IP and it's one of the most intangible, the most valuable assets of any particular company with respect to music companies, with respect to film production companies, with respect to designers companies, with respect to engineering firms and engineers themselves, scientists and tech founders. IP is their currency of value. IP is their currency of value. And the reason why I say this is that because without intellectual property protection, Nigeria creatives, now the Nigeria creative boom risks becoming an unrewarded industry where pirates, middlemen, and foreign companies benefit more than their originators. Now, what this simply means is that without IP as a currency of value, anybody, middleman, without necessarily the originators of the ideas, we aim more than the originators or owners or authors or creators of works. Because we must understand that there's a chain of things with respect to how works get to the market, with respect to how works are marketed, with respect to how works are distributed. So IP is a currency of value. And equally, I want to actually ask this particular question before I proceed further. I equally want to ask and say, have you or anyone you know ever lost money or credits because someone copied their work? Have you or anyone you know ever lost money because someone copied their work? Now, I will quickly answer that. You can drop your answer on the chat, but I will answer that for me to just quickly proceed because I have 20 minutes. I've seen and about to go to court respect to individuals and persons that have had to lose money because their work was being exploited without them being credited with respect to that particular work. And one of such instances is in situations where music that were created by individuals were used as ringback tone without necessarily the licensing or assignment from the copyright folder being given some of the tech companies that use those songs as ringback tools.
Okay, Mr. Emmanuel is still having challenge with his network. Please let us bear some patience. Sometimes there can be challenges with network, so please let us bear. Mr. Emmanuel, welcome back, sir.
Hello, can you hear me?
Yes, sir, we can hear you.
Okay, I apologize once again. I think the network is a bit very bad. I've changed to another internet to see how best I can manage this. Can you see my screen now?
Yes, sir, we can.
Okay, so I'll just quickly continue. So I was talking about that creative industry in Nigeria, why intellectual property matters. Now, there are several reasons why intellectual property matters in the creative industry. As we all know, Nollywood produces about 2,500 movies yearly. About 2,500 movies yearly. Could be more, but statistically, that's what I thought. That Nollywood produces about. Look, can you hear me now?
Yes, sir, we can hear you. It seems your network is quite bad.
The network is really bad. I don't know why it's now that we're having the presentation that the network is so bad. Okay, so I'll just run through it. So basically, Nollywood, as we all know, contributes so much with respect to revenue generation in Nigeria GDP annually. And as at 2023, the Nigeria Bureau of Statistics stated that Nollywood contributes about 239 billion to Nigeria GDP. Yet, Iris cost Nollywood about 82 billion yearly, as it was reported. Now, some of the legal frameworks and things that we understand with respect to laws that regulate the industry, particularly in Nigeria, with respect to IP protection, the Copyright Act, Trademark Act, Patent and Design Act. We have the TAB, we have Film and Censors Board Act of Nigeria, we have the Nigeria Data Protection Act, we have equally the Federal Competition Act with respect to consumers protection and all of that. I'm just trying to rush through to at least before the network starting again. Now, some of the key IP type for creative and inventors, I will equally just want to talk a bit on this. Now, one of the key IP parts, though I will have to talk back on the laws, it's when you talk about the Copyright Act, specifically as it relates to some of the key things and laws that has to do with creative and inventors. We'll be talking about protection of musical rights, protections of themes, protections of, because these are categories of work. Because when you talk about copyright, you're talking about copyright protect works that are with respect to intellectual creations. And for a work to be copyrighted, it must be one of such work that are subject with respect to work that are protected under the Act. And for those works that are protected under the Copyright Act, You're talking about literary works, you're talking about musical work, you're talking about software, you're talking about dance, you're talking about recordings and all of that. Those are some of the categories of work that the Copyright Act protects. Now, if a work does not fall under some of the one of the subject matters that are protected under the Copyright Act, then the Copyright Act cannot protect such work. And we must equally understand that copyright with respect to works does not protect ideas. It protects works that have been fixed in tangible forms that can be seen, perceived, or that are in forms that can be future or through technological means can be seen. And all of that. Those are the type of work that copyright protects. And there are two key things with respect to copyright. The two key things is originality and creation. Originality and creation. The work must be original, and to an extent, the work must have been put in a piece form. And I gave an example with respect to every time Burna Boy, the last stream or license, he aims royalties. And the reason for which he aims royalties is because his work has been pieced in a piece form and it's original. And someone has licensed that particular work that's now in a streaming platform. And whenever that particular work is now being streamed, is given for form of royalties as credit to him with respect to that particular work. Now, when you talk about trademark protect works like brand names, logos, slogans. And when you have popular brands, for example, you have MTN is a brand, and that particular brand name is protected. You have Coca-Cola, it's a brand, that particular brand name is protected. Just so on and so on. You talk about Aquafina, you talk about the popular Apple phone, you talk about Nokia. Those are brand names and their logos is protected. Just imagine that Apple logo is placed on a patch. Once that Apple logo is placed on a patch, what first comes to your mind with respect to that particular Apple logo is issue of, oh, this must be quality, this must be durable, this must be a good product. Because you see that the goodwill that follows Apple, once it's placed in a particular thing, even that makes it to be more expensive than others, because you know this must be quality, it must be durable and all of that. Apple is classic, Apple is and all of that. So you want to showcase. So there's something that follows the brand's name. That's a brand identity and goodwill. And so once you see that MTN everywhere you go, or Innocent and all of that, their logos are all trademarked and protected because there is something that has to do with their logo, which is their intellectual property right. So for anyone to use their brand name and logo that does not have their license, we are marked for infringement with respect to their intellectual property right. So whether it's a creative or an inventor, for you to be able to use a specific logo that is not yours, then you need licensing. Or even your logo that you're invented as an inventor or creator, you usually need to protect it because that's your identity in the marketplace. That's your goodwill. That's what people see, and they're able to see whether they're able to tell, oh, this is an asset name, this is quality, this is a brand, this is something that if I buy, oh, I'll feel good about it. Just imagine that you're driving a Mercedes Benz and you just see a car with a metal, oh, this must be a very good car, all of that. So there's something that has to do with the brand name that says to you with respect to creative and inventor. So it's important that you protect your brand name, you protect your brand ID, logos, trademark, and all of that, slogans. So for patents and industrial design, I will just merge both together. Now, patents protect inventions that are new, that are novel, that are capable of industrial applications. That's what patent protects. And you equally have industrial design that protects. Industrial design protection covers artistic feature of the product, such as its shape, patterns, ornaments, that makes it virtually unique. For example, if you look at the Coca-Cola bottle, there is an industrial way at which the bottle looks like. That design is protected as an industrial design. That's what makes it standard and all of that. There's something that has been ongoing currently in Nigeria that has to do with geographical indications. In other parts of the world, this is something that already is being protected and there are laws with respect to geographical indication. But particularly for Nigeria, hello, can you hear me? Hello, can you hear me?
Yes, sir, we can.
Yes, sir.
Okay, now for geographical indication, Geographical indication is new in Nigeria, and currently there have been movements and there have been proposals with respect to protections of geographical indication. Now, it protects products linked to their places of origin, giving them global prestige and premium value. For example, if you talk about father rice, originally from Ogun State, we talk about Adere. I know a lot of us that are professing that are Yoruba. It's a traditional Yoruba tie and dye fabrics. Now, do you know that just like champagne from France, Swiss wash when you're looking at it and all of that, a product like father rice, Adere, Kilishi would gain global recognition and fetch higher price if properly protected. And that's what geographical indication does, because it makes that particular work for a particular region so unique to that particular region that it can put a price tag to it that it gains a higher price value than the marketplace. And that, I think that's where Nigeria is trying to equally get to. Now, this is just some fact check that I did online, and I discovered that according to the World Bank 2023 report, only about 10% of Nigerian innovators formally protect their IP. Only about 10%. And that's a very low number. Because IP, like I said, is one of the most intangible, most valuable assets of any company, of any creator, of any innovator. So it is important that one of the primary things you will do is to protect your intellectual property right. But surprisingly, Nigerians do not do that. So I equally asked the question in my slide, and I said, which IP type do you think creative and inventors in Nigeria neglect the most, and why? Because I've seen several in my work, and when you talk to some innovators, you talk to some creative, they don't see a need for even legal. They don't even see a need why they should do formal protection. They just say, yeah, somebody just invest and we just set the idea and all of that, and it just ends there. Or we just get a producer and all of that, and it ends there. And you'll be like, have you registered this particular work in your name? Have you trademarked that particular logo, that character, that slogan? And they'll be like, do I need to trademark? And you'll be surprised and be like, no, it's important. Because it gives you a competitive value. It adds value to whatever amount that you want to sell your creative idea. It gives you a higher bargaining power with respect to negotiating a fair price for a fair deal. So I've seen often a time that a lot of creative neglect copyright protections. A lot of creative, because now, don't get me wrong, copyright with respect to work as it relates to the Copyright Act of 2022 automatically subsists in the work once it is placed in a fixed form. But I tell people that you must go a second level higher by way of registration. And what it does is that it gives you a second level layer of protection with respect to evidential values, with respect to showing and projecting or selling your work or licensing or assigning your work. You can show certifications that this work is indeed registered, showing some level of credibility. Because what the NCC does, that is the Nigerian Copyright Commission, is that that is central depository for which if your work is registered, that anyone that search can see that indeed you have priority of title. So it is important that creative and innovators register their work. Now, what are the common challenges? Hello, can you still follow me?
Yes, sir.
Okay. Can you follow me?
Yes, sir. Yes, sir.
Yes, sir.
Yes, sir.
Okay. Okay, that's good.
Okay, I think Mr. Emmanuel's network is still giving him some challenge. He's almost done with his slides, so sorry again about that. Once he comes, I'm sure he's going to wrap up his session, and then we'll have our other two mentors on the call also give their presentations. So once again, so sorry about the network challenge on ground.
If you can put off his camera, I believe his network would be better.
Um, Yes, I'll notify him to do that once he joins back.
Hello, can you hear me?
Yes, sir, we can hear you. Please, sir, if
Network.
it's possible, can you turn off your camera so that maybe it will improve the quality of your
Hello?
network? Hello, sir, can you hear us, sir?
Yes, what did you say?
I say, can you put off your camera? It may increase the quality of your network.
Okay. Okay, can you see my screen now?
Yes, sir, your slides are up.
Okay. So I was talking about some of the challenges, and one of the challenges that I was able to point out is with respect to piracy and counterfeiting. And another challenge is low registration culture. Most creeds don't fight for protection. And that was the reason for which I gave you that particular report with respect to the report that talked about only 10% of creative protect their work. And another challenge I would have is with respect to weak enforcement. Now, I think this could drag for years in court. But with respect to the trademark registry, if we give some level of credence to them, with respect to the Nigeria Copyright Commission that now has tribunals for which some of these intellectual property disputes are resolved. Some of them have not been facilitated. However, some persons even after the tribunals are given verdict, equally still appeal some of these decisions. And because we don't have specialized courts that take our time and say this is the only thing that you do, sometimes in the regular court it drags once it goes to the federal court, which is the court that has been stated by the act as to the court that has jurisdiction for enforcement. So the weak enforcement procedure is equally one of the challenges that we currently face. Another challenge that currently has become coming is cross-border exploitation. I want to talk about Nigeria Afrobeats release abroad, that royalties. If you go to YouTube, if you go to Twitter, if you go to online space, because of the advent of the internet, a lot of things and work that are just released here in Nigeria, someone can just get it in the US and start distributing to different platforms, and it is shared and all of that. But thank God for YouTube that has a platform for which you can flag copyrighted work, for which you can equally report work that has been infringed, and YouTube will flag those videos and ask you to take this particular work. Even Facebook has that technology now. That is only to tell you because as technology advances and some of these challenges with respect to cross-border exploitations, there are equally some technological advanced methods that have been put in place to ensure that some of these exploitations are mitigated upon. Now, what is the link? I'm trying to rush the work so that our slides will not be going up and down, and I'll just go a bit into some of the things I've spoken on. Now, what's the link between IP as a livelihood and the leverage? Now, the link, IP as a livelihood and leverage. Because one thing you must understand as a creator, because the topic is not abstract, you must understand that there are something that every creator wants is to be able to get monetary value with respect to their work. As a creator, as an inventor, you want to make money from the work. And that's what intellectual property does. It gives you the ability to monetize your work. So you're able to get royalties, you're able to get licenses, you're able to get merchandising deals with respect to your work. How many of us have watched football or any of the major matches with respect to the Olympics and things that are played? Now, one of their major source of income is the protection of the intellectual property right with respect to who broadcasts that work, with respect to merchandising deal and sync agreements. Now, the merchandising deal, have you seen a school bag that has some of the players' name? Have you seen a school bag that has some of the theme for the year, football, and all of that? So there's merchandising. You can even see it in school bag, you can see it in cups, you can see it in children's penny bottles and all of that as a promotional material with respect to the advertisement of those particular clubs, all their players, and all of that. Now, once those things are done, the club, the players get monetization with respect to their image rights if their image is being used. That's an intellectual property right. With respect to the company that has license over the work, licensing and saying, oh, you can broadcast my football performance that is currently live People pay. So you see that it's some certain channels, if you are not subscribing to this particular channel, you don't have access to it. And as such, they are making monies with respect to that particular work. So that's why IP is important as a source of livelihood. Now, it equally gives you leverage, because even though you see Michael Jackson, someone said something to me one time and said at the point of the death of Michael Jackson that he made more money than when he was even alive. Those money came from royalties, from songs that were played all over the world when he died. Persons were trying to remember him. A lot of persons started playing the song to also remember the memories of what Mike Jackson, who he was and what he did. And for every time they played those songs, the estate of Mike Jackson was making money. So it's important that you leverage your right. Equally for persons that are alive. I don't know how many of us have heard about the Bridgewater scenario with respect to the Ungo dance. Now, what happened is that because of that singular dance challenge, a song that ordinarily would have been dead came back to life, and that man got some money again. That's Bridgewater had to pay some level of money to say, all the money that came out from this with respect to information, I gave it back to the man. I did not get anything. That's leverage. You can equally use it to take money with respect to work from bank. It can be used as collateral. Your IP right can be used as collateral. That's leverage. Now, you can equally use it to expand, to attract investors and global deals. A lot of the movies that we see currently that's shown in Nigeria has been sold to Netflix. And some of them have been sold to Primes. And they are now being televised all over the world. And the producers of those particular movies, even before production, they get the money for productions and extra cash to do other productions. The actors for those movies, they get fully paid even before they started acting their roles because of IP rights that is being used to expand and attract investors and get global deals. We talk about defense. Now, enforcement rights in court. You equally need and you must show that indeed you are the intellectual property owner with respect to those creative work for which you're saying that have been infringed upon. That's where I talked about registration. It's important. Either you're trademarking that particular work, either you're copywriting that particular work, either you're patenting that particular work, either you're getting a license with that particular work, either there's a clear agreement with respect to percentage sharing, if it's a work of co-ownership, or their collaborations with respect to those specific work. It helps you to defend those particular work. Now, with respect to negotiation, stronger contract with platforms like Netflix. You cannot come to Netflix negotiation table and you're saying, I'm the owner of this work, but I don't have the IP registration certificate. They will not take you seriously. If ordinarily you're supposed to get 20 million, they'll pay you because you don't have certification registration certificate, they will pay you 5 million. So for you to have stronger negotiation power, you must be able to show that indeed you have certifications and evidence backing your claim of intellectual property ownership with respect to this particular work. And I asked a very simple question. I said, do you see your creative or innovative work as just a passion or as an asset you can leverage like land or shares? I've come across a lot of creative, and they don't have this passion or see their creative work as an asset that they can leverage on, like land or shares. And that's the reason for which you see people who just sign these and they will be attached to a production company for 10, 15 years. I will just be singing to you and I just give me 1 million. Because they don't know the value of what they have. Because if you don't know the value of what you have, you can just say, I will give you one deal with respect to a particular hit song, and you pay me this amount for it. So you want to be singing for 10 years of your life for one particular record label without attaching specifically the number of contracts that you want to produce. So it is very important that you have specific understanding as to that this is a passion or it is an asset that you can leverage on, like your land or shares. I see IP as an asset. I see IP as one of those land things that you can sell. I see IP as an intangible asset that can create money for innovators and equally for creative. Now, I will just equally give these simple tips to mentees. I know I compress some of my talk on this particular topic, just so that, hello, can you follow, or are you following me?
Yes, sir, we are following.
Okay. So some of the practical tips that I said here for mentees is that register your work, trademark, registry, NOTAB, NCC, whether it's in Nigeria, movie and licensing board. You need to ensure that you register your work. Use contract in collaborations and licensing. Protect digital content with watermark, with digital rights management tools and all of that. And you must learn to think global. I've seen a lot of persons and they'll just say, I just protect my work in Nigeria and that is all. No. You must understand that with respect to some certain type of intellectual property, they are territorial based. And as such, if you're targeting an international market, protect your work equally in those markets. WIPO registry is there. ARIPO registry is there. You can use it as a form of protection with respect to your specific work. Now, IP, livelihood, legacy, leverage. Nigeria creatives and inventors must stop leaving money on the table. Your ideas are valuable. Protect them. Don't just post them. Thank you. I don't know if I've taken 20 minutes already. By now, I've already done 20. Hello.
Thank you very much. Thank you so much, Mr. Emmanuel. We learned quite a lot from the presentation. We sincerely apologize once again for your network. I know that it was something that you struggled with while presenting, but all the same, sir, much. Can you hear us, sir?
I can hear you, but I heard you very faintly.
Oh, all right. I was saying thank you for your lecture, sir. We learned quite a lot from the things you shared.
Okay, thank you very much.
Yes, sir. So we'll be going over to our other two mentors that we have on call for their own discourse too on the topic. We still have other two mentors in the class. We have Mrs. Regina, and we have Mr. Sand with us. Thank you so much, Mr. Sand, for joining in. But before we go to Mr. Sand, we'll be taking Mrs. Regina's presentation or discourse on the subject matters IP for creatives and innovators. You're welcome, Ma. The floor is yours, Ma.
Thank you very much, Dennis. Can you hear me? Can you hear me? Please, can anyone hear me?
Yes, ma'am, we can hear you.
Yes, can hear you. Okay. Thank you for this great opportunity. In a few minutes, I'm going to be speaking to the topic, IP for creatives and innovatives. I'm not going to share a slide. I'm just going to speak to the topic. And what we're talking about, because Mr. Emmanuel has really gone deep on the subject matter, so I'm just going to touch a few points. IP for creatives. So before there are creatives and inventors, there should be an intellectual property. I believe we understand what IP, intellectual property, is, who is an inventor, and who is a creative. An inventor is an individual that invented the subject matter of the invention. In Nigeria, inventions are protected as patents under the Patent and Designs Act. An inventor may apply for the grants of patent rights by a relevant government body. It's important to know that it has to be an independent government, like we have Biafra cannot grant a patent right. Nigeria can, Ghana can, US can. So it has to be an independent government or a regional body like the ARIPO, the OAPI, the EUIP. So in Nigeria, patents and designs grants It's under as Patent and Designs Grant, which is done by the Patent and Designs Registry. It's under the Ministry of Trade and Investment. So upon examination of a patent application, the patent is either granted or refused. And if a patent is granted, the inventor or the patentee, as the case may be, is granted exclusive rights to exclude third parties from exploiting the invention without his or her prior authorization. So if anyone attempts to or does any of the acts in terms of exploiting the patent without his prior authorization, that would amount to patent infringement. So the patentee or the patent owner can bring an action at the Federal High Court, an infringement action. So I was talking about patents for inventors. So when you hear patents, it should be for inventors. And creators, how you have copyright. And very briefly, I will talk about what's the concept of AI in patenting. AI simply means artificial intelligence, and it's simply the intelligence of machine or software as opposed to living beings, that is human beings. And we should also note that there has been some major controversy or arguments as to whether an AI can or should be legally recognized as an inventor or a patent owner in some countries, including Nigeria. Of course, in Nigeria, based on our laws, an AI cannot own a patent. We refer to section 2 of the Patent and Designs Act, which was specific as to a patentee has to be a human person. So in reality, a patentee in Nigeria must be a human being as at today, except the law changes tomorrow. Generally, patent laws require human inventors, and the debate continues. Some countries have started recognizing AI inventors, such as countries such as Australia, South Africa, and some others. In some other jurisdictions, both the courts and the Houses of Assembly have repeatedly restated the fact that AI cannot hold a valid patent. The US, for instance, has re-emphasized the fact that a patent should be issued to a human person. And New Zealand, Japan, and some other jurisdictions. And in some jurisdictions, so there are three main arguments. One, on the one side says that it has to be a human being, a full human. Then the second argument is that an AI can be a patent owner, can be granted a patent. And some jurisdictions have held that a patent application with an artificial intelligence inventor, that's an AI, must identify at least one human inventor, such as the EUIP and UK and some other countries. So once there is a human inventor, they can recognize an AI as an inventor. Thus, the patent can be granted to the applicant, provided that the grant is not only to the AI, and there's a human aspect. A creative, on the other hand, that's for patent and inventions. A creative, on the other hand, is a person whose efforts or job involves creative work. And this can be likened to content creators, as we have all over the internet. We can see them on Facebook, TikTok, Instagram. I believe some of us mentees are also involved one way or the other in content creating. And that it's important to also know that this is now a major source of income to most individuals, especially the young ones and even the older ones. Even companies now venture into content creating. And we see young people becoming influencers. Businesses invest heavily in creative efforts, creative work, and most organizations, we see them engage in these online influencers, to promote their businesses, to promote new products, and to even advertise upcoming events. And also, some lawyers now also specialize in representing content creators. Can you still hear me?
Yes, ma'am.
Okay.
Yes, ma'am.
Thank you. I'm rounding off already. The Copyright Act of 2022 is the primary legislature that protects the works of creatives. We can also see the Trademarks Act. That is, the Trademarks Act may also come in at some point to protect trademarks, trade names, or brand names. We are aware of popular names of creatives. The Burna Boy, the first speaker mentioned Burna Boy. We know of Celine Dion, the Kardashians, Davido, Oga Sabinus, there are many of them, most of which may have been trademarks. Most of these names may have been trademarks, most of them trademarked at the Trademarks Registry. So the copyright law is the most, as at today, most progressive of all the IP laws in Nigeria. So under the Act, there are works which are eligible for copyright protection. And this simply means that there are works that are not eligible for copyright protection. And the eligible works were categorized into 6 categories, which are the literary works, musical works, artistic works, audiovisual works, sound recordings, and broadcasts. The works that are not eligible include ideas. We know that copyright is automatic. So if you have ideas that are not put in a fixed form, they are not eligible for copyright protection. Discoveries, mere data, the fact that you extracted the mere data, there was no creative efforts, such kind of outputs are not eligible for copyright protection. Official state symbols and insignia, which include flags, coat of arms, national anthem, banknotes, and the like, are not eligible for copyright protection. I mentioned also that copyright is automatic, copyright, unlike other categories of IP rights like trademark, patents, industrial designs, and others, which must be registered. So there are 2 basic requirements. The first speaker mentioned that for copyright protection, which is originality and fixation. Originality simply means that the work is original, and fixation simply means that the work has been fixed in a particular medium. I'll be stopping here. So that the little time we have left can go around everyone. Thank you for listening.
All right. Thank you so much, Ms. Regina, for the thoughts you have shared. We really sincerely do appreciate. So we have one more mentor that is in class today, and we hope to hear from him very soon. Also share his thoughts on the topic IP for creatives and innovators, and then we'll go to the presentation from the mentees. So, Mr. Sand, Thank you so much, sir, for joining. We're happy to have you in the session today with us. Please, sir, we want to hear from you in the next 20 minutes here about share your thoughts on IP for creatives and innovators. Hello, Mr. Sand.
Yes, I can hear you. Thank you very much. Regina, thank you for laying the foundation of the discourse this evening. I suppose we are all in Nigeria. Even if we are not in Nigeria, we're not far from our time zone. Thank you very much, Emmanuel, for that detailed presentation. I think I'll just open my video before I go off because of the bandwidth. I've learned a lot, and it's always a big issue when one have the opportunity to speak last. So I was asked to share my thought on IP and inventors. And when I saw the topic, I said it's interesting. I believe this is the first time. I'm not sure now. Just correct me, Mr. Moderator. Where at Jiipcc, I think I've been with you guys for the past 3 years, I think. But I know I've been with you guys for some time. I've been with a lot of mentees. So maybe still correct me, where we are connecting these IP. I know there has been always IP and business, IP and inventors. And in my subconsciousness, I started asking myself question, do we really have an inventor in Nigeria? And this is a question to us. So do we really have an inventor? Who comes to mind when you say inventor? Because if you say American inventor, we know them. But who is an inventor in Nigeria? Do we really have one? Mentees, you can unmute and give me a name of one inventor. Let's look if it's really an inventor. Give me a name. It's conversation. I'm not giving lecture.
Sir, I don't think I can put a name to it, but I know that some work has been done. Even particularly in the north, I have heard of some people who have worked on engines that can convert maybe water that can use water as a form of petrol, and some people also use water as form of gasoline, right, to power cooking and the rest. I think we can qualify those persons as inventors.
Who told you? You say some people. What is the process it went through? I'm not trying to, but I just want you to just consciously consider these things as Africans and as Nigerians. And maybe from your tribe, maybe if you want to step it down, you can. And that is one of the reasons why, okay, Regina?
Yes, I wanted to also add that Nigerians are inventors, but for most of the well-recognized inventions, I don't want to say that they are not invented in Nigeria. If you see the inventors that have created really interesting things that have helped all over the world, most of them are Nigerians, but they're not really staying in Nigeria.
Okay, you see now, I'm not saying most of them everywhere. They've created so many things. Give me a name. Because it's one thing for us to go, even in diaspora Africa. So it is one thing for us to say, Nigerians are creating, they've created so many, but give me the name. That does not mean that they're not there, but give me a name. Give me a name. I saw someone drop Innocent. Fantastic. Chief Innocent. Voila. Innocent Motors. Would you qualify Innocent as an inventor? would you qualify innocent or an assembler? You know, is another brand just assembling things, just to say, just repackaging, rebranding. Will you qualify him as an inventor? Do a Google search. Because because that means there is, because okay, so I'm a promoter of the All African IP Summit, which is something that we've been pushing for over the years, and this is like the 6th edition that we're moving across Africa. And one of the drivers, so also to disclaim, I'm not a lawyer, and I don't hold any beef against lawyers. Lawyers say sometimes I say lawyers are the problem of Nigeria. No, not in the sense that you are looking at it, but you know, where we have made law and IP as sesame twins. They are together. They cannot because law defined how we engage things. So from the perspective of my lecture today, is a conversation I want to stimulate our thinking from the textbook perception of what IP is, and a creation of idea or in the mind, you know, those stuff that they're okay. But in the African context, in the Nigerian context, do we really have an inventor? IP and inventor. I'm not talking about IP, I'm not talking about inventors now. You see, IP, my vision in IP, I'm a trade person, I'm an international trade person. So for the past 15 years, 20 years, everything I do is trade. What I do then, I then realize that you can do trade. You can export cashew, you can export coconut every season. Nigeria is the highest, they just banned cashew nut, shea butter. Nigeria is the highest exporter of shea nut. Why are we not producing it here? We ban it. And I say, no, you can't ban it because it's a free market, because I'm a free market person. Now, I didn't realize, and I think as mentees, this is what you should start looking at. I didn't realize that I can promote trade as much as I can, but for sustainable trade, there should be an underlying IP system. So I see IP as an enabler of trade, job, wealth, sustaining wealth. And I like what Emmanuel said, and I wrote it down. IP as an asset to leverage and bequeath to people. Tell me in your neighborhood, how many business? Let me start from the top. I think my video is on. I think you can hear me well. If you can't hear me, I turn my video off and then I speak directly to you. And I am also conscious that this mentees also need time. This is Friday, although maybe it's good. So Friday, but at the same time, Friday, most times you have to unwind. You don't have to be in a classroom. But let's take this today. It's just 3 weeks or so. You can go through all this stuff. So because it's knowledge that will help you tomorrow, that will make you stand out. Now, back to my story. I then realized that for trade to be, so how many businesses? 100 years and above. Do anybody know any business in Nigeria is 100 years and above? Nigerian business. Oh, let's get it. Oh, Nigeria, 100 years. Do anybody know any business that is 50 years and above? 50 years. Going. Does anyone in this room knows any business that is 30 years and above? Does anyone knows any business that is 20 years and above? 20 years, yeah, we do have them.
And look, anybody is 30 years and above.
Oh, fantastic. 30 years and above, fantastic. Who again?
Oh.
Dangote should be 20 years and above now.
Dantata manufacturing company.
How many years?
I think it should be about 40 years plus.
Great. And so it's great. It's great. So now we have to interrogate these things. IP, you people invited me to have conversation on IP and inventors. They both good. So a business that is 40 years and above should have Emeka Uzo. hail from Ojota, small community in Idemili. Okay, so he has a business. So, but now when they ask him, Dan Tata, have you seen Dan Tata inventing stuff that we can say now? This is from Dan Tata. So we have issues in Nigeria. This is where I'm going to now. We have major issue in Nigeria. We have power issue. We have, now they give us band A, band B, band C. So now the cost of energy is high. And we have AC, we need to have AC. Have you seen inventors, Nigerians, with all this problem? We still have Lanta that has invented AC that has inverter, that even when there's no power, it keep on blowing to be able to solve this. This is what we are going, this is what we should be thinking. We should not see IP as one of those textbook thing of thinking, but now we've mentioned trademark, we've mentioned that is an abstract thing. Step it down. Can we see a product that is, can we see a pen? And that, by the way, that's stuff you talk about, fuel running on water. Why is it still just someone in Kano just doing it? The guy is still very poor, looking haggard. He has not taken a step, or nobody has, no investor. Effort is being made. I think things are changing though. And that's why at the All Africa IB Summit, you want to have an exhibition, an innovation hub, IP marketplace. Come and tell us ideas and tell us how you have that. This is addressing your local challenge, and how you protecting it so that it gives you opportunity to create job, to live well. We have all manner of sickness here. We still have vaccines still coming from outside the shores of Nigeria, shores of Africa, and we are saying, we have everything. We have everything. I'm a strong advocate of GI. We've been speaking about this GI forever. And someone from Obodo Igbo gave us some funds to work on drafting an IP ecosystem, a legal system for geographical indication, which is something naturally is ours. But I have to still be saying I'm advocating for it to be considered as a bill. Institutions that don't even understand it. It's lying there. This is a GI. I'm not talking about this is a GI. This is a simple thing. And I think Emmanuel, fantastic. You did a fantastic job. You broke it down what address is, what a father right is. This is something like nature gives to us. What is wrong with us as Black people? That is the question. What is wrong with us as Black people? We have a system. We have something that has given to us. We can't even just come together to see that we scale it up. And I think Regina that also spoke about some of the things that we have that is natural to us. And yeah, I think Regina made reference to it, Emmanuel made reference to it. How many cartoons are from the, I think Emmanuel also spoke extensively on it, that is a brand name where it has gone from just becoming a product line to cartoon to things that make people relax. I talked about, we have power issue. So why would we just solve the power issue? Why has there not been inventors in Africa, in Nigeria, to solve this power issue? We have we are still importing drones. We have insecurity. Why have we not invented things that will protect us? You know, most of the inventors come from military. You see, this internet we are using, it was a way to circumvent hacking by the enemy that the military man include. So we have military people. All their guns from China, from Russia, we've not invented our own. And it's true, Regina said, Biafra cannot give a trade rights, also my independence. It's true. But you know, those guys, those time, just a little bit of conversation we're having. How I wish this is physical, where we can interact and share our thought, because by learning, you share thoughts. I don't know it all. Of course, I don't know it all. I believe that you guys, that people I'm speaking to far better know it all. But what is the system we have put in place to be able to support people that have an idea, to create it and to take it to the market? Brand it. It's not raw. You do fuel and oil. Has it gone through science? So I believe in a number of things of science. Spiritual is there, but I feel it's an abstract thing. You can't fortify it. So if power is fuel, if water can fuel an engine, take it through, subject it to a scientific process, go to patent, design, protect it. So because they ask you questions, it goes through that process. And they say, okay, they put your name to it, everything matters, the cover and everything. But why are we not paying attention to these details to get this done? IP and inventors. In Nigeria, inventors are non-existent. My view, inventors are non-existent. Yeah, IP is still in the primary stage, and that's why the primary element of IP in Nigeria that we should be talking about is what we're having. We're having this conversation so that we stimulate your concept. And I went through some of your presentations. Great work, but more effort needs to be done. You guys are too booky for my likeness. You are young. You should be able to step out into doing some more robust research in your work. But it would be good to listen to you people. So let me zero in a little bit on Innocent, because it's the inventor and seeker. So when I use the technology that we have now, search engine, Google, AI, I use AI for research as well. So it's not a bad thing for use AI, but you have to know what you are looking for to use it. So sometimes it gives you wrong thing because it's still learning. And it's someone that invented it. And we have Juju here. We have Juju. You know those Juju from the village, masquerade, that stays in this thing. He has never come to invent how we can to fly from Lagos to Abuja within 5 seconds. But they say we fly every night. We've not converted it. We have inventors. They say it's to suck blood, but it's rubbish. But we need people to invent those, to turn those things around. So when I did this search, which is AI, it's big data coming together. It's okay. They actually recognize Pastoral. He started somewhere, he's assembling. So I think he's scaling up a little bit more. But Innocent should have moved faster. It's a conversation. I'm not going to giving you all the stuff. The legal people are giving you legal, but I want us to think inward to bring us solution. The finding identify Innocent as the first manufacturer, and as a matter of fact, the finding also showcase Innocent as an inventor. So that means that even if he's inventing the wheel spanner, he's doing something. But I've not seen him find things. But maybe it's still secret. Maybe he has five things. But he said he used industrial design and trademark to differentiate his car. Yes, the trademark logo, someone came 2 years ago and said, we designed this logo like this, it doesn't look catchy. He said, no, it is my invention. So his Innocent is trademarked. He has used industrial design to do some maybe wheel spanner and everything. His car parts. He's now exporting it to other African countries. So you can look at it. This is product from Nigeria. But you see, how I wish an average, and this is where I would end my conversation. As I say, we are speaking to young people, even while you are learning something that will be better for you tomorrow, is also good for you to also live your life when you're young. I cannot imagine myself being in classroom by this time on Friday when I was in university. I'm still in university, I'm doing my PhD, but then being in university, being in classroom by this time. But it's something that will pay you off tomorrow, because by that time, I didn't have conversation on what IP is or even know what I wasn't talking about. But you guys are doing very well for participating. So, lesson is this. So, he competes, he's exporting, he's an identity. But do we really have, from industry level to national level to subnational level, policy on IP? Say, we're setting out investments, X amount of money to support inventors. Have you ever heard of it? Inventors. No, we even have mobile phone up to this time. Hey, up to this moment, not even a pouch we can even create as Africans or Nigerians. All we do is import. How are we going to be prosperous, for Christ's sake? IP is not about monopoly. It's not a foreign thing. It is with us. If you want to create wealth, you want to sustain investment, you want to sustain growth, you must have an IP system. And you must have an IP policy that supports you. Every day you must say, even in your organization, even in your, I'm in a knowledge environment, You must recreate something that you so is identify with you. Then what you do is to go and file it in the what you have now to protect it, to as well market it. IP itself does not give you wealth, but there's another element that goes with it. Up to this moment, we don't have anybody in Nigeria, although I heard someone saying some young folks, so I work on trade ecosystem, a number of things, both digital trade, digital identity, payment system, on the policy angle, very strong on it. So yesterday I was in Lagos. I'm back in Abuja, I'm based in Abuja. And someone was telling me that some young folks have discovered a way whereby you can do money transfer without internet, an instant. And he went to see for investment. He said, how much have you raised? He said, it's $200. You're not bankable. And they say they're not bankable. But this is a creative way. So we have internet issues. This one we have internet issue. And someone is creating innovative way through code. He should be able to protect those stuff. But I don't know if he couldn't raise money. I hope he raises money. So if we have a policy that said every inventor is entitled to $1 million, boy. Look at what happened with Nollywood. So now, let me even ask, how many of us know Iroko TV? Iroko TV. Let me see. Iroko TV, anybody? Thumbs up, give me a thumbs up. Iroko TV. You know Iroko TV? Okay, how many of us know Netflix? Okay, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. Okay, Netflix, yeah. Everybody is a hinting now. But these are things you see as challenge. I'm just trying to make us understand that we should move beyond some things. So from government level, you should have IP policy. As an organization level, you should have an IP policy, and we've not spoken about it. And there's a different level. So policy, it should be for the development, and there are some resources that should be associated with that policy to ensure that it works. So the young man that has invented a way to make payments without using the internet is an inventor that needs to be protected and invested in for him to be able to grow through labs, and individuals are creating it, where he becomes famous. And if we don't have power, and someone can be able to say, we can use with the way fuel is now, and even the CNG is not even working, you can give us water to fuel our vehicle. Government should have pumping a lot of money to that stuff. But if they're not doing it, does that mean that thing has not subjected itself to test? Or nobody is, because if we don't do this, we're going to remain poor. Unfortunately, that is just reality, because nothing stays here. Everything I'm speaking to you, I'm sitting in the office, everything on my table, 99% are foreign, even to the extent that the face cap I have here is foreign. The t-shirt is, the design is not from here. So how do I create wealth? How do I not export wealth? So for me, in summary, IP is an enabler of trade. IP is an enabler of IP is wealth. IP is creating opportunity domestically and as well as creating jobs. IP is livelihood. IP is school fees, school fees, quality health. We have malaria, we have all manner of sickness here. We've not even still translated. Even when we have the herb, we can still farm them. Say this herb heals people. Let's farm it. We have a policy that says this herb is a national asset or is a local asset. Nobody kills it. We farm it. We do more research that we still we don't get it. We don't get it. We don't get it. We're still far away from a lot of things. Think is this thing, but no nation developed from this stuff. Go and help the people that discovered this ban. Our police should have a research academy, do research on how to ensure you track crime without this is inventing it, so you create solution to solve issues on ground. But very soon there will still be flooding. Nobody has invented a way to be able to address it. Ladies and gentlemen, thank you very much for having me. As I said, you guys are investing into your future, for coming to listen to boring people like us, and as well as me listening to your presentation and enjoying it. because that is what we have signed up to. But I would expect, since this cohort would go on doing stuff, be a little bit, go beyond just giving us the textbook presentation, expatiate, give us real life experience, and also test run some things. When you come and say, I think this idea will blow me up tomorrow. I can bequeath this asset to my children. I have gone to even register my name. You know, someone registered his name. So Regina talk about Sabine. Of course, they registered their name now. You can't go and say Sabine's this thing, Sabine's, call your own Sabine's. They will sue because they have money now. They're a brand. But you can even start from something. Before now, and as I tell you, we don't know everything. Before now, I used to think that although because and one of the reasons why I had that position in the past is that it's expensive to have IP systems. So it's currently, you can't just go and file trademark and get it done in the next 6 months. You can't even get it. It's taking maybe 2 years. And after 4 years, you have to go and renew or so. You might appear me, you can confirm this. So I feel you just start doing your business. When you think you start making money, then you start going to it. But over time, then I realized that business itself and life is risk. Start both sides. As you are filing your CAC or your business name, go and do your trademark and start from there. As trademark, you start inventing things, you start creating stuff. So that when you want to go and seek for investors, you put your logo and say, this is my logo, this is my brand. Because of what I put into that I know is unique. It's worth $1 million. So I am valuing my business with one customer, that is me and my dad, $1 million. I'll tell you, come on, guy, what is wrong with you? But I say, but I can see that I can blow up tomorrow. Come and invest in me. Okay, if you think I blow, what other thing have you done? I'm just joking anyway, but I believe that when you want to start a business, that should go. And most times, we can also adopt the Chinese model where, and that's why the IP policy comes in. The government has to take IP serious, where you set funds aside, not just for start business. Not you say, we do a lot of things the same way, because there's no focus. Even our electricity plug, no design has come from Nigeria. It still comes from outside. No one has reinvented things. Can we turn things around, young men and women? I rest my case on. And I do well for inviting me. So I'm here to listen. And thank you very much, Mr. Moderator. Over to you. Hopefully we'll have so it's those people that are out. Nobody even go out these days every night. But I can be talking, just talk sharp. But no, because nobody goes there because the economy is tough. Because no idea. Everything is exported. We've exported everything. We import everything. We import idea. We import everything. So the money doesn't stay. And do you know the part of one of the things that IP? When you do your profit, if you have a business, you take your value for your IP before you even pay tax. So I don't know, lawyers. Can you confirm that? Because I know this is what happened. That's why there's also a strategy of moving these things around. Oh dear. Anyway, yeah, thank you very much. I hope I've been able to communicate. My way of teaching is just to have conversation, because what else do I want to start defining? If your theory cannot be converted to real value, it's still relevant to me, because that is what life, even social good. We are poor people. We are really poor. Forget about this thing that people are running themselves around. But to create that wealth, we need a strong IP system that we have to ensure we stimulate that wealth. Wealth creation is man-made. So the same thing with an idea. You have problem, you solve it. My glasses, so at some point, there's this glass that I use, right? You can see my glass is the same. But do you know what builds into a heat that makes it too expensive for maybe that glass? You'll be shocked. But who is taking time to look at these things? My wristwatch, they say it's Swiss wristwatch, very expensive. I've used it for years. Like a man that wants to be president, say how do you have this wristwatch? But if you look at the value of that wristwatch, it's forever. Yeah, because it's quality. Because like the IP built into it is a build about sustainability. So let's think IP beyond rhetoric, right? Thank you very much.
All right, thank you so much, Mr. San, for your thoughts that you shared with us. We really, really appreciate. Our mentors have done well to share their thoughts with us in today's class on the topic. So now we want to hear from the mentees. Please, I think we're quite far spent on time, right? Please, can we can we have our presentation as quick as possible, 10 minutes each for both groups, so that we don't waste time? So group 3 and group 4, it's your turn to present for this week. Can we have the presenters for group 3 come up to make presentations on behalf of the group?
Good evening, everyone.
Yes, good evening, Mr. Victor.
Yes, I'm presenting for group 3.
All right,
Okay.
please, you can go ahead and share your slides and start your presentation. Please try to make it as quick as possible, 10 minutes, so that, we can still stick within time.
All right. So, um, all right. Can you see my screen?
Yes, sir, we can see your screen.
All right. So, meaning of intellectual property for creatives. Intellectual property gives legal protection for our creativities and innovations. For creatives, intellectual property covers things like books, dance, music, softwares, and other arts or designs. It ensures that once you create something unique, the law recognizes you as the owner and gives you the power to control it as an asset. Intellectual property is aimed at making you use and view your creativity as an asset. First one here is literary works. Literary works includes novels, plays, blogs, and other academic works. In Nigeria, literary works are protected by the Copyright Act, and the protection lasts throughout the lifetime of the author, and also an additional 70 years after his death. IP gives the owner of a copyright the exclusive right. It gives the owner of a copyright the exclusive work, publish it, perform it, and distribute the work in order to prevent plagiarism and piracy and other challenges that the owner may face. An example of illustration where copyright can be used in literary work is in the case of J.K. Rowling. J.K. Rowling copyrighted Harry Potter, and he had exclusive rights to license translations, film adaptations, and also merchandise. And he was able to build this into a $1 billion franchise. Also, we have Wole Soyinka. Wole Soyinka generated global royalties from his works. As the first African laureate in literature, his plays, essays, and poetries, they are protected by the Copyright Act, and he was able to generate royalties. Illustrations on how failure to enforce IP can lead to revenue loss. An example here is Jiipcc Things Fall Apart. This work lost royalties. This work lost a lot of royalties to piracy, despite the global recognition of the book. Also, George Orwell's Animal Farm. This work was also pirated in Asia. This work was pirated in India, and it lost a lot of royalties as a result of the piracy, despite the book also having global influence. Right. So visual arts. Visual arts includes paintings, photographs, sculptures, graphics. We have the architectural designs and other visual works, and they are protected by the Copyright Act also. This is important for artists in the sense that they use IP to protect their creative works and also to ensure fair return while marketing it. Intellectual property law ensures that visual artists protect their creative works. It helps them see fair returns in the market. Example of the case is Katia versus British Sky Broadcasting. In this case, the owner of the copyright was able to protect a design against misuse. He was able to protect his design against misuse. And also we have the Star Athletica versus Varsity Brands. In this case, uniforms, that's the cheerleading uniforms, they were deemed to be protectable by the law. Also dance, yes. Section 108 of the Copyright Act recognizes and defines choreography as a protectable property. For such choreography to qualify, it must be composed of movements or any other patterned gesture, also accompanied with music. In dance, The ownership of a copyright is usually with the choreographer, and the copyright comes automatically. But as our mentors have pointed out, registration of a copyright can also strengthen a legal claim that might arise out of it. It gives the choreographer exclusive rights. It gives the choreographer the exclusive rights to the reproduction, performance, publication, and broadcast of the work. Nigeria has no landmark case regarding dance, but a dance, yes, not any dance. A dance cannot just be copyrighted. A dance cannot just be protected. For a dance to be protected, it must show that it is a choreography and that it must have been captured in a material form. That is, it must have been recorded as a video or written. Example is in Alfonso Ribeiro versus Epic Games. In this case, the court dismissed the claim of a plaintiff to protect a dance. This should be because it is not a choreography as defined by law. Okay, music. The main IP tool protecting music is copyright and trademark. I think I have the wrong slide here. Yes. Can you see this screen now?
Yes, we can see your screen, Mr. Victor.
Yes. The main IP to protecting music here is the copyright and trademark. As we said earlier, a copyright is a protection that grants exclusive rights to the owners of literary, artistic, or musical works to publish, display them, and sell them. When a song is copyrighted, it is always in two categories. That is, the first one is the composition, and the second one is the sound recording. The composition is always for original lyrics, melodies, and the sheet music, while the sound recording covers the original recorded song. In Nigeria, copyright laws grant automatic protection, but it can also be registered. And registration of a copyright strengthens a claim that may arise out of it. And the duration of a copyright in music is throughout the lifetime of the creator, with an additional 70 years. Also, trademark. Trademark protects names, logos, slogans, and labels and label identities. Example is the Marvin's Record, the YBNL Nation, and the Coldplay Music Band. Trademark helps in ensuring that brands are recognized, their goodwill and reputation are protected, and also to prevent confusion in the marketplace. A very good example is the African Songs Limited and Adigbe. In this case, King Sunny Ade was awarded 500 million naira for infringements of his songs. Also, the MGA Entertainment versus OMG Girls. In this case, the jury awarded $71 million for the unauthorized likeness used in the dog brand. I think this case is not Nigerian. Yes, the jury awarded $71 million for the unauthorized use in a dog brand. We have the software programs. Software instructions written in code that makes the device perform tasks. Examples are Windows, WhatsApp, industrial apps. The IP tools used in software includes copyrights, and this copyright protects source codes and object codes, and it also stops unauthorized copying of the work. Also, patents. These patents protect data and security algorithms, and patents here works for duration of 20 years. Also, we have the trade secrets. This trade secret protects confidential methods like the Google search algorithms. We have the trademarks. This trademark secures names, logos, slogans like the Microsoft Word. And example of the protection of trademarks in logos is the bluebird icon that was formerly used for Twitter. The bluebird icon used in Twitter, now X. Also, case examples of this are Apple versus Franklin. In this case, software code was ruled by the courts to be copyrightable. And we have exemptions. These other two cases are on exemptions to it. In Oracle versus Google, the Supreme Court ruled, the US Supreme Court ruled in favor of Google that the use of APIs was fair because they are functional tools necessary for innovations and broadcast. The Copyright Act serves as a foundation for protecting broadcast, audiovisual works, and scripts in Nigeria. Rights are automatically secured. That's once a work is fixed. Once the work is fixed, the right of intellectual property, that's copywriting about it, is fixed already, and it is not mandatory, but it strengthens claim. Once registration of intellectual property is done, it strengthens any claim that can arise out of it. The Nigerian Copyright Commission, that's NCC, it functions as the central body for registration, enforcement, prosecution, and public education on copyright. Also, the National Broadcasting Commission, it regulates the broadcasting industry through licensing, compliance, and standard settings, making it an important player in protection and management of broadcast-related intellectual properties. The film. In the movie industry, the film is protected by the Copyright Act. The protection also is automatic, but registration also can strengthen claims. In the trademark law protects film names, logos, and brands. Example here is Funke Akindele Production. Ownership of a trademark or copyright in film always lies with the producer or production company as the financer. Example is CP versus Shan Rajit and others, where the producer was deemed the author and copyright holder. Also, Section 28 and 30 of the Copyright Act gives of a copyright to the financer unless it has been reassigned by contract. The duration of copyright in films are 50 years, while in literary, musical, or other artistic works, it is 70 years. The Nigerian Copyright Commission, NCC, enforces rights with police, customs, and courts, while the National Film and Video Censor Board, the NFVCB, protects and regulates film exhibitions, licensing, and distributions. So moral rights survive even after economic rights transfer. And I think, yes, this is the end of the presentation.
All
Yes.
right. Thank you so much, Mr. Victor, for making that presentation on behalf of your group. We really appreciate the efforts you and your group put into making the presentation. So thank you so much, and well done to everyone that's put in effort to compile the presentation. So please, we'll be going to group 4. Please, just like group 3 didn't waste time, please, group 4, we would like to have your presentation as quick as possible so that we can move on to mentors' feedback and then we can take questions. Do we have the presenter for group 4 in class?
Yes, I'm available. Good evening.
Good evening, Mr. Daniel.
Okay. Good evening. My name is Peter Daniel. I'll be presenting on behalf of Group 4. So, if I go into the subject, I'll define IP as a legal framework which protects our inventions, designs, symbols, names, images, and literary works. These are things people come up with through creativity, innovation, and the law protects them from unauthorized use. In the presentation, we'll look at how IP plays out in different industries, specifically in engineering industry, the communication industry, medical industry, pharmaceutical industry, and technological industry. First of all is the engineering industry. In the engineering industry, patents are especially important. They protect inventions like engines, robotics, and unique processes. Licensing agreements also matters because inventors can allow other companies to use their patents in exchange for royalties. That is, these are the payments a party who is called a licensee gives to another party who is the licensor, that is the owner of the IP, for usage of the products in question. Trade secrets such as special formulas or blueprints are also widely used to protect valuable knowledge. For example, is James Dyson patented his bagless vacuum cleaner technology. Because of these patents, competitors couldn't copy his cyclone design, and that protection had allowed him to build a billion-dollar company. But there are also stories of losses. Example is Robert Keynes, who invented the intermittent windshield wiper, but didn't secure proper licensing. Car companies used his idea without permission, but he later sued and won. But by then, he had lost years of potential revenue and recognition. This shows how vital it is to secure IP early in engineering. Next is the communication industry. In the communication sector, patents cover things like mobile networks, antennas, voice compression, and even 5G technology. Trademark protects brand identity, like MTN slogan, that everywhere you go slogan, Airtel's red wave logo. Copyrights cover ads, jingles, websites, and even software codes. Licensing allows telecom companies to share and profit from their patented technologies. An example is Qualcomm as a case study. They don't manufacture most consumer devices, but they hold patents for technologies like 4G and 5G. Instead of making phones, they license their technologies to companies like Apple and Samsung. In 2022 alone, they earned over 6 billion. That's the power of IP strategy if used correctly. And then another example is Nokia versus Apple in 2009, where Nokia claimed Apple used its wireless technology patents paying. Without paying. Apple countered with its own claims, but eventually Apple settled by paying Nokia a one-time fee and ongoing royalties. This shows how IP disputes can shape the global communication industry. Next is the medical and pharmaceutical industry. In medicine and pharmaceutical industry, patents protect drugs, medical devices, and manufacturing processes. This is crucial because companies invest billions in research and development and need assurance that they will recover their costs. Trademark also plays a role. For example, in names like Panadol or Tylenol, they protect those names from abuse from other, let's say, people, organizations, and companies, and they help build trust with patients. Copyrights protect medical software, research materials, and publications. Licensing allows drugs companies to distribute their medicines globally through partnerships. A good case is Pfizer patent on Viagra, patented in 1996. Pfizer had exclusive rights to sell it worldwide, generating over $35 billion before the patent expired. That protection not only rewarded Pfizer, but also funded new research. So why is IP crucial? It derives on innovation by giving scientists incentive to create new treatments. It helps fight counterfeit or fake drugs, and it ensures society benefits from safer, more effective healthcare solutions. Next is the tech industry. The tech industry lives and breeds IP. Patents cover software, algorithms, chip designs, and touchscreen gestures. Design patents protect the looks and feel of devices, like smartphone icons or layouts. An example is the iPhone logo at the back and the design of the cameras and so on. Copyright covers code, interfaces, and digital content. Trade secrets safeguard confidential tools like Google search algorithm, while licensing allows tech companies to expand their reach. For instance, Google licensing Android OS to manufacturers. Apple, an example is the Apple and versus Samsung case in 2011. Apple sued Samsung in 2011 for copying the iPhone design and interface. Apple initially won over $1 billion in damages, which just shows how valuable design patents are in tech. But there are also missed opportunities, like, for example, is a Xerox PLC invented the geographical user interface and mouse technology in the 1970s, but didn't secure patents. Later, Apple and Microsoft built products using similar ideas. Xerox lost the chance to dominate the market despite being a pioneer. That shows in tech, having innovation is not enough. You need to protect it with IP. So to wrap up the presentation, why IP matters. Firstly, it's encouraging innovation. Inventors and creators know they will benefit from their work. They know that their inventions and their ideas are safeguarded, and they will benefit from it. It will be beneficial for them. Secondly, it protects commercial value. IP can generate revenue through licensing, partnership, or even litigation, while also increasing company value. Thirdly, it prevents unauthorized use. IP gives inventors the legal power to stop copycats and stay competitive. So across engineering, communication, medicine, and technology, intellectual property is not just about law, it's about protecting ideas, driving progress, and shaping industries. So this is the end of Group 4 presentation. Thank you for listening.
All right. Thank you so much, Mr. Daniel, for presenting on behalf of Group 4, and to the person helping to share slides. Thank you also. We really, really do appreciate the efforts and the commitments and time that has been put into the work. We want to say hold on once again to both groups. So moving forward, all right, we'll be taking feedbacks from our mentors and then taking questions. So please, if you have questions, you can prepare your questions on ground so that we can take, let's say, 3 or 4. Right, so we'll be taking about 3 or 4 questions in today's class. So please prepare your questions for our mentors so that after we take feedback, we can go ahead and take questions and not waste time. So I think starting first with Mr. Emmanuel, if you are still with us, sir. I see you are still with us, sir. Please, we'd just like to hear from you what you thought about the presentations based off of what was sent to you and also what they presented in class. If you also have any extra thoughts you would like to add as regards the topic for today, please, sir, you can do so in the next, I think, 10 minutes, sir. Hello, Mr. Emmanuel. Okay. I'm not sure Mr. Emmanuel is with us. So if Mr. Emmanuel is not
sorry. Hello, can you hear me?
Oh, okay, we can hear you, sir.
But sorry, can you come again with the question? I didn't get that.
Okay, so sir, we asked if you will be able to give some response to the presentations that were made by the mentees based off of what was submitted to you and what you listened to in class.
Okay.
And also if you have any other thing you would like to add to the discussions for today in like 10 minutes, sir.
Okay, with respect to the presentation, I would just simply want to say that the mentees did a good job with respect to identify some of those laws that can protect innovators and creative, and the specific areas that equally need protections. But just to equally broaden their understanding with respect to how IP work, I equally want to say that with respect to specific work, one, you can have several intellectual property rights with respect to even an engineering innovative work that has been created. And as such, so it's not that because I equally want us to just get this background understanding that it's not because you copyright a work, then you don't need to patent that particular work or trademark the logo or brand name or identity. It could be several different intellectual property elements with respect to specific work, whether it's a creative, whether it's an innovator, being an engineer, or someone in the film industry. And with respect to intellectual property work, you necessarily do not need to now say because you're giving someone credit, then it's enough. I know one of the presenters said something on that, and I only want us to take that seriously because I've seen a lot of persons make that blunder because of the age that we are in currently, most especially on online. They'll say, but I give credit to him and all of that, and so should just use this work. It's not sufficient. You want to use any particular work, you must learn to license those particular work. And I think Sam said some certain things that are very interesting that I think we should equally take very seriously. With respect to, we must look at the business angle of things and how IP is an enabler of business. It is not to stifle or cripple your creativity. It is not to stifle or cripple with respect to, you will not be able to get more business. No, but rather it's giving you better and more opportunities and stronger negotiating powers. And once we start looking at it from that particular perspective, while we innovate, while we create, we look for innovative ways to create things that we fully protect, and indeed to create things that are original. And he said something with respect to if indeed in Africa we have innovators or creators. We must now learn to look inwardly and not just copycatting what already exists. We must learn to improve things that we can say and say, oh, this is the originality with respect to what I've created, and make it distinct from what already exists. That's improvement. I think I will just leave it at that. And I will say, okay, thank you for everyone that has created. And more so, we can learn to look at local cases. When we say some of these scenarios and all of that, and we try to tie it to foreign cases, there might not be a lot of law reports, but there are local incidences that have occurred within our environment that we can use as reference points. And it makes people and all the audience relate more with the things you're talking about. I will just leave us with that. Thank you for having me once again, and thank you for all the mentees for the well done job and presentations that were done.
All right, thank you so much, Mr. Emmanuel. We enjoyed your comments, the comments that you made, and I hope our mentees were paying attention to the things that you said. So moving forward for Mr. Emmanuel, if we have Ms. Regina still with us, please, Ma, we also want to get feedback from you as to what you think about the presentation and if there's any other added information you would want us to know in today's class.
Okay, thank you so much. I think that the presentations were good. I love the fact that I think group 3 had a lot of visual appeal that somehow would make the audience to remain focused. And then group 4 had a number of case studies. In fact, a lot of case studies, which shows the length they went to explaining the topic IP for creatives and inventors. I believe that those case studies, although there were many, but the groups that decided to use case studies could have gone deeper. I mean, explained in more details, just like Emmanuel talks about. So that would not only show that they've understood what those case studies, the issues that were in the case studies, but it will clearly help to explain to the audience, those listening, the issues and the solutions. And if there are areas where the mentees are getting it wrong, and that is why the mentors are here to clear out those areas. But in all, it was a great presentation. Thank you to groups 3 and 4 for that. Thank you.
All right, thank you very much, Ms. Regina, for your feedback. Lastly, we'll go to Mr. Sand. Mr. Sand, if you're still with us, we want to get feedback from you, sir, before we take questions.
Thank you very much, Mr. Moderator. And I have to also commend joining under mentors to commend the mentees for a job well done. I personally have gone through your presentation before now. And as I said in my own opening remark, that it was very informative and as well as speaks to the subject matter has given to you. I also want to thank my colleague, other moderators, for also their comment. They said it all. Those of us said, because I went through your presentation, I know it was what was given to you. But we appreciate, as Emmanuel has, other mentor have said, is that use more local case study going forward. Referring to, see, Africa has a lot, but they said we don't have anything. They taught us how to read and write. And we don't have anything. They taught us how to read and write, but we were communicating before now. Where I come from, women have always been leaders. When in Europe, women were made full-time housewives. Because women have been leaders. In Europe that time, just a little story, women that speaks out are thrown into, especially in England, they throw them into the river. You know, they wear this buba, this white stuff. If they don't sink, they bring them out and burn them alive as witches. So that means, and over time they realized that it was wrong, they changed it. Now they are coming to tell us now that we are not allowing our women, as in women, gender balance and turn things around, because they keep on telling their story, we can't tell our story. So we keep on, when we have a slighted opportunity, we go back to them and refer to their story rather than our own story. Mentees, do a little bit deep research. Bring us case studies that are locals. Don't tell us women have more voice in Europe, African women don't have voice. When originally our mothers were given a voice, it was Europeans that came to tell us that women are supposed to be in the background, they're not supposed to be seen. And now they're telling us that women are supposed to be given gender equality. And we are also driving towards that because we've also failed to tell our story. I'm saying, in essence, connect the dots. Tell more of our story. Give us more of stuff. You have an opportunity to make a presentation. While you have to be given a topic, you can go out of it. But again, congratulations and well done for your work well done. But is it well done to the scale of 50 in a pass mark? 70 is a pass mark. 90 is a pass mark. But if you say well done and you're giving 50, what happened to the other 50 on top? Aspire to get 100%. Aspire to get distinction. The people that have it, the people that invented solutions that we praise, that we make reference to in our stuff, can as well be a Black man. Make your work a little bit more original, and you will find it fulfilling. Thank you very much.
All right, thank you so much, Mr. Sand, for your feedback. To the mentees, please, as much as we can, please let us try to be more inclusive in our presentations of more local examples and case studies, if we can, while we do or carry out our research. So please, we'll be heading over to questions. We are a bit over our time for today, but we will take questions, I think about 3 questions, and then we would call it a day. Okay, I can see one question in the chat box. Okay, question from John. John is saying, considering that Nigeria has weak enforcement in IP issues, as a Nigerian, sorry, I kind of made a mistake. Okay, sorry. He said, considering that Nigeria has weak enforcement in IP issues, as a Nigerian filmmaker, are the other practical steps to take to protect your film from pirates, especially from the everyday infringements from digital streaming and online distribution platform? So I'm looking at your question, and I'm wondering if you're asking what are the other practical steps to protect your film from piracy. All right. So Mr. John's question is on the chat box. He's asking for other ways filmmakers can protect their movies from piracy rather, right? And from piracy, especially everyday infringements from digital streaming and online distribution platform. So please, if we can, to the mentors, the question is an open question. I think I would want to go straightly direct it to Ms. Regina. Ms. Regina, if you can see the question, what are your thoughts about it?
Yeah, thank you very much for that question. The first speaker was very elaborate on piracy and its issues. As part of the issues, we definitely IP protection in Nigeria. So, as a filmmaker, and I also understand that filmmakers and producers in Nigeria go through a lot in terms of piracy and infringement of their intellectual effort. I know that also in terms of protecting or preventing piracy in Nigeria, because there are very difficult or stringent enforcement procedures. You're going to spend a lot of money to be able to, get these regulators to assist. The first speaker mentioned a lot of those steps. And I think that's one of the ways that people have tried to prevent copying, which is a form of, infringement, is by using watermark. And in the new Copyright Act, there is a very elaborate and broad provision for takedown in terms of online copying. It is very elaborate in the new law that if your movie, because most movies that we see these days are streamed online, and that is where piracy or infringement has moved to in today's film business. So I mentioned that the Copyright Act has a very elaborate provision on takedown procedure, which just says that if your content is original and it's fixated and there is an infringement, just notify the platform. I believe that those that are very familiar with most of the social media platforms like Facebook, you would note that once your work there is a copy of your work and you notify Facebook, they are very quick to react. So the first step is to notify the platform owner, and if they don't take a quick action, they could become jointly liable for the infringement if the matter gets to court or to the NCC. So you can lay your complaint and the infringing content will be taken down immediately. I think these are the basic steps, but generally, these are issues that creators face around these parts of the world.
All right, thank you very much, Ma. Or okay? Thank you very much, Ma. So please, do we still have more questions for our mentors? Do we still have more questions? Please let us ask questions. They are here to also add to knowledge, fill in gaps in terms of gaps of knowledge, gap of where there is no proper understanding. If there was a concept they shared on today that you did not properly hear, or you want some kind of clarifications, please do well to ask your question. We are taking questions from the mentees. Who has questions? Does anyone else have a question that they would like to ask? Do we have questions? Do we have questions?
Yes, I have a question, and I've typed it in the chat box.
Oh, okay. Please, but you can just go ahead and ask. All right, while your mic is unmuted.
All right, I asked whether there is a means to announce protection of one's intellectual property to the public, and especially in the creative industry, like how will the general public be aware of the existence of an IP protection?
Sorry, please, can you come again? I don't think we heard you properly.
Okay, I'm sorry.
All right, my question is there a means to announce protection of one's intellectual property to the general public, like especially in the creative industry? How will the general public be aware of the existence of an IP protection? So like for them to be aware and then avoid any form of infringement.
Okay, all right. Thank you for your question. Mr. Emmanuel, if you are still with us and you heard the question, please, would you like to share your thoughts on how to, or if there are means around that?
Okay, I think I already answered that question on the chat, but just to put in some clarity with respect to it. Now, when your work is copyrighted, the minute the work is copyrighted, it's a sign that you can put on all of these works. You can use the copyright sign. You know that C sign on your work. So any individual that see that particular work would know that that particular work is a work that has been copyrighted. So you can equally go further to use and write in ink that this work is copyrighted by so and so, or unauthorized use are not allowed. If you want to, you must have to contact the owner of the work for licensing or assignment with respect to this particular work. For trademark, there's equally something known as TM sign. The TM sign, you see a T and an N in a circle. For trademarks, for logos, for names and all of that, for words that have been trademarked. You see underneath all of those logos of company sign, there's something that is small that is known as a TM sign. So for every work that you see, look closely at MTN logo, look closely at all of those major stuff. You see a very small sign there showing TM. So for those in the creative industry, whenever you see that work, if you're someone, you know that this particular work is trademarked, this particular work is patented, this particular work is copyrighted. Now, because of the advent of technology and with the introduction of the 2022 Act, now you can use different technological measures. There are something known as timestamps that can put on this particular work and say, well, this particular work is protected by so and so persons. You can use watermarks. So, and the Copyright Act even went further to say anyone that use any technological measures to circumvent any of the signs that have been placed in a work showing that it has been copyrighted is guilty of an infringement and is equally liable for punishment. So you can use different technological measures if you can online materials to show if it's a watermark that this particular work is protected once you're sharing that particular work. Even if you're selling in a marketplace, underneath your work, you can put and state to the general public that that particular work is copyrighted and unauthorized use is prohibited with respect to so and so work. So you can use smaller word statements. You can use the authorized logos and signs or symbols that can be placed in work. So if anyone see that work for the general public, you take notice of the very fact that that work is copyrighted. So that's how the general public know that that work is copyrighted. Now, for people that want to do due diligence to know whether a work is copyrighted, the ones they don't really see that sign. If your work is registered, there's something known as the register for registered work, a depository where they can go and conduct search. For example, if it's a copyright registry, go to the NCC, conduct search. It will come out and show that that particular work is registered. If it's a trademark registry, to conduct search under the category of class of work for which a work has been trademarked, it will come out to show that, oh, this particular work has been trademarked under so and so class. A register for which the general public can search online, just like you do your CAC search to know if this particular name already exists in CAC. You can do a public search on the CAC website to see whether a name already exists. You usually have that with the respective registries.
All right, thank you very much.
I don't know if I've answered your question. Okay, you're welcome.
Thank you so much, Mr. Emmanuel, for helping us with that question. Okay, Ms. Regina, please, you can go ahead. I can see your hands up.
Oh, thank you so much. And thank you, Emmanuel, for that answer. I want to also add that, you know, besides or aside trademark patents, which there are signs to indicate that these have been registered, copyright protection is automatic, whether or not there is a sign. Once you created the work and it's fixed in a particular medium, whoever sees it, however you put it, the work is protected. So you having the sign added is just going the extra mile. So whether or not there's a sign on it, copyright is automatic almost all over the world.
All right, Sma. All right, Sma, thank you very much. Okay, I'm trying to see if there are more questions. Is there any more question that we would like to ask before we totally call it a day in class today? Any more questions? All right, in the absence of any question, I would like to say a very big thank you to Mr. Sand, to Mr. Emmanuel, and to Mrs. Regina for helping us do due diligence to today's topic. We talked about IP for creatives, IP for inventors, right? And I trust that we have been able to learn a thing or two from today's class, right? Our mentors have taken us through both practical discourse on the subject matters. They have given us definitions and also shown us practical ways for works to be protected. So please do not forget to share what you have learned. Do not forget to fill your attendance. And also do not forget to work with your team members when assigned to a new task. New tasks will be sent out most likely today or tomorrow. So please pay attention to that. And what else? I think with that, we have come to the end of today's class. Thank you all for sticking to the very end. I know we went a little bit off time, like we spent more than we had allotted for the class. We sincerely apologize for that. We'll try our possible best to work on our time management, but all the same, the process is worth it in the end, and we are learning and we are becoming better. See you all in the next class. So our mentors, please do enjoy your night rest and good night, everyone.
Good night.